My guest today, Jay Knight, is a partner at Bass, Berry& Sims in Nashville. Jay and I have been friends for quite some time, even before he served in the SEC's Division of Corporation Finance. When he was living here in DC, we co-taught a securities law class at George Mason's Law School, and he's done a great job blogging at Bass, Berry, the Securities Law Exchange, for the past several years. I'm Brock Romanek, today on Zippy Point. So Jay, thanks for doing this with me. It's such a novel concept to actually teach a little bit on incorporation by reference. When you're a young lawyer and you hear that term, it's such a complicated thing to understand. Maybe you've heard it outside the legal context, but maybe it just is some sort of legal artifice to cobble together a full document, a full filing to meet the SEC's requirements for a particular form. I liken it to like a jigsaw puzzle. You're jumbling of pieces. So what you're doing is you're actually taking either a full document that you file with the SEC and pretending that it's also part of another document for filing purposes, liability purposes, or maybe you're taking part of that document if you're allowed and incorporating by reference into another filing. So then when you're filing this document and you're incorporating pieces of that other one, legally they're considered one. And they're as if it's filed anew for purposes of that document it's incorporated into. So that gets to be important when you're talking about liability purposes, because when you made the original filing, the liability that attached to that might be at a certain level, but when then you're incorporating that part of the filing into another filing that might have stronger liability provisions, you're actually taking on more liability for that same disclosure. Yeah. For those of us who are seasoned practitioners, we can't imagine a world where there wasn't integrated disclosure. That's what we're talking about here. But right before I started practicing myself in the early 80s, that's when the integrated disclosure, the self-registration system came into effect. And the practice was so controversial when it was first introduced. So I do want to pull up the speech. This is from 1983. Commissioner Treadway gave in Hot Springs, Virginia. You can see here the manual typewriter at work. But he talks about in this speech that I actually pulled from the SEC's website about how controversial it is. And there's like a history lesson that he gives harkening back to 1940 and all that. So it's hard to believe today that this would be controversial, but it was at the time. All right, enough of the history lesson.
Well, it's pretty amazing how with the incorporation by reference, like when it was adopted, it really was kind of a legal fiction. I mean, it was like a legally created fiction, but things have evolved so much now that you can literally with electronic hyperlink to the information, and for the average person on Edgar, it is essentially the same document electronically. So it's kind of interesting how far we've come from where we started.
So before Jay digs into the rules, let me give a few examples. So your 10K will be incorporating prior reference likely forwardly to the proxy statement and perhaps pulling things from the rear, things that have already been filed, the 10Q, the 8K, particularly in the exhibits. And then your 33 Act registration statements, your deals, once you're more seasoned and if you're a larger company, you have eligibility to pull in all sorts of these 34 Act filings, your 10K, your 10Qs, your 8Ks, and perhaps sometimes the proxy statement. I don't think you need to in many cases. And then also in like a deal where you get near shareholder approval, you're going to have a combined prospectus proxy in many cases. In the old days, you actually had to have two separate documents, but it's been quite a while now, probably 30 years, that you can combine those into one. I remember, I won't even tell the story.
All right, so 12b-23 essentially says in Part A there that unless the form provides otherwise, you can incorporate by reference into an Exchange Act filing. So your 10Ks, your 10Qs, your 8Ks, you can incorporate by reference outside of those to pull in the information that you need, unless the form says otherwise. And in most cases, it doesn't. Most cases allows it. One exception there in the financial information in 12b-23b limits incorporation by reference and cross-referencing in the financial statements and information outside of the financial statements. And really that's driven so that the auditors can opine on the information that's in the four corners of the audited financial statements. So So keep in mind that's, it's not just incorporating by reference, it's cross-referencing to information outside, which is a broader standard. So keep that in mind, particularly with the financial statements. And then in exhibits, you're allowed to incorporate that information by reference as well. With hyperlinking now, which is in D, that's really been a game changer for incorporation by reference, because now any information that is incorporated by reference into your filing from an existing filing, you need to hyperlink, essentially. And so, it doesn't have, if you hyperlink from one section to another section, so say like in a 10K, you're in the legal proceedings section, and you say, for the legal proceedings, please refer to our contingency footnote. You don't have to hyperlink within the same document like that. But for if the item that you're referring to is an existing filed 8K or 10K or a particular section, then you would have to hyperlink. And that's really been I would say, a structurally fundamental change in kind of incorporation by reference in the past couple of years. That's really been it's really been helpful for investors and users of these financial statements and filings.
Yeah, so this is an example of what Jay's talking about in the exhibits here to the 10K for Microsoft. This is the exhibit index, they actually have hyperlinks for each of the exhibits. So useful. Before you had this, you had the links, you actually had a note about where the document was filed 5, 10, 20 years ago, or maybe a year ago. And you would have to go look at those various filings. But here with a click, you can get to many, many, many documents.
Right. It's much more user-friendly now.
So let's look at, this is the Form 10K. As they go through the items, this is the form itself. As you go through the items, they're mentioning where you would pull that from. These are items like MD&A is going to be in your glossy annual report typically, and so it's incorporated by reference here into item 7. Then this is the 10K of Microsoft itself. When you get to the various items that are incorporated by reference as required by Rule 12b-23, and also instruction G to the Form 10K, you're going to describe exactly where in the proxy statement you were forwardly incorporating by reference these items from.
Yeah, I think incorporation of reference is really one area where companies, as they're trying to reduce and kind of modernize their disclosure and reduce just the amount of pages on filings, can really, this is one area where a refresh and just look, is there places you can incorporate by reference and kind of thin out some of your disclosures and not be redundant. So.
And then Rule 411 is the 33 Act analog of what 12b-23 says, and this is what that ends up looking like in a prospectus where you're allowed to, when the company's eligible for incorporation by reference. That's why it's so important to be timely with your 34 Act reports, because if you're late, you'll become ineligible to use Form S3 if you're below the WIXI level status for a 12-month period. And so, companies that are late, sometimes they try to get a waiver from the corp fin staff, so they're still eligible to use an S3 if they think they're going to be doing a deal in the next 12 months. The waiver threshold is pretty high, but sometimes you're able to obtain those. But this is what it looks like in a Form S3, where you can find more information.
And yeah, because this is on your Form S3, you're incorporating by reference your annual report and your 10Qs that you filed since your fiscal year end, as well as any current 8Ks that were filed and not just furnished. So that's, and as well as your description of securities. So that's why these are hyperlinked in blue, because you can actually click on those and go directly to them. And then for future filings, obviously you can't incorporate, you can't physically hyperlink those, so you can list those, you list that out. We're also incorporating by reference future filings, but you don't include a hyperlink on those, obviously.
Great, thanks very much, Jay.
Glad to help.